If you're in the United States and you are undocumented and you don't have a U.S. citizen spouse or child that could potentially file for you, well, this video is for you. Let's talk about options that are available for someone that's undocumented and does not have family for them to get a green card. I will give a caveat at the beginning of this video that some of these options may change come January 20th, but I will be mentioning how they may change as I go along. You should stick around because number 4 is one of my personal favorites that a lot of people don't know about or have misconceptions about. I am U.S. Immigration Attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. The first option is asylum. This is one that people know but may not understand very well. In order to get asylum, you have to show that you have been persecuted or that you fear future persecution based on your race, gender, ethnicity, nationality, political opinion, or membership in a particular social group. You also have to apply for asylum within a year of being in the U.S. If you miss this 1-year deadline, that does not mean you can't apply for asylum. It just means it's going to be harder for you to get asylum because now you have to show why you were not able to file within the 1-year deadline, why you waited so long to apply for asylum. A change in your country's circumstance or in your own personal circumstance can help explain the 1-year deadline, but you have to make that argument either with the immigration court or with USCIS before they can actually approve your asylum. Once your asylum is approved, you are now able to apply for a green card in the U.S. You just have to show that you have been in the U.S. for at least 1 year, and then you'll be able to apply for a green card. Now, let's talk about the changes that could happen with asylum in 2025. With the new Trump administration, they have mentioned that they plan on limiting the particular social group. So membership in a particular social group is a more expansive thing than race, ethnicity, nationality, right? So they want to limit that as much as possible to limit who can fit into that particular social group. But as you're working with an immigration lawyer on your asylum case, as changes in law happens, they're going to be able to adjust and make different arguments or enhance their argument to show that you still fit into the particular social group or have a different social group established for you. The next option available for someone that does not have a family in the U.S. is a U visa. A U visa is a long-term process because the process can take about 15 years. However, if you qualify for a U visa, after you get your U visa, you can apply for a green card after 3 years of having your U visa. The U visa is based on you being a victim of a particular crime. There are a list of crimes that the U.S. Congress has basically said these crimes can qualify for a U visa. So if you fit into one of those and you have been helpful to law enforcement, then you would qualify for a U visa. You do have to show that you have been helpful to law enforcement, and the way to show that is to get a certification from the law enforcement agency that says that you've been helpful, what the crime was, and all of that. They will sign off on that document, and then you'll be able to apply for a U visa. You do have to show that you have suffered harm and that you are a person of good moral character. However, if you're able to show these things, you can apply for a U visa and then be able to get your green card once you've had the U visa status for 3 years. The downside to a U visa, like I mentioned, is that it can take up to 15 years for the U visa itself to be approved. So that's why I say it's a longer term plan. It's not going to get you the green card right away. Now, let's talk about the change that will happen with the U visa. If you have a case that has been closed and is no longer active with the law enforcement agency, the Trump administration would want to make it so that you would not be able to apply for a U visa, limiting the amount of people that can actually apply for a U visa. Right now, the way the law is written is that if you have been a victim of a crime, regardless of when you were a victim of that crime. Let's say you were a victim of armed robbery a year ago, right? And the case is now closed, you can still apply for a U visa. Let's say you were a victim of attempted murder 20 years ago and you are able to get a certification and apply. As of the law today, you will be able to apply. However, with the new Trump administration, if they pass their U visa changes, they will make it so that if the case is not currently open, you would not be able to apply for a U visa. The next option is specifically for children under the age of 21. If you are a child under the age of 21 and you have been neglected, abandoned, or abused by one or both parents, and you have a court order through the family court in your state saying that you have been abandoned and given someone else guardianship of you, then in that situation, you, as the child under the age of 21, with that court order, will be able to apply for SIJ status, which is the Special Immigrant Juvenile Status. Again, this is only for children under the age of 21. Once you turn 21, you would no longer qualify for SIJ status. Once your SIJ status is approved, though, you would then be able to apply for a green card and then eventually apply for citizenship. One caveat with SIJ status is once you get status under SIJ, you would not be able to ever file for your biological parents because, again, in order for you to get the SIJ status, you have to have shown that either one or both of them abandoned, abused, or neglected you. So they make it so that the parent cannot benefit from you getting that status. The fourth option is the T visa. This is my personal favorite because this has very short time between you filing and you being able to get your green card, as opposed to the asylum and the U visa. The T visa is for victims of trafficking. So sex trafficking, labor trafficking, all types of trafficking. As long as you can show that you were trafficked and that you suffered harm due to that trafficking, okay? You have to show those two things. And you also have to show that you are a person of good moral character. And when USCIS talks about good moral character, they're just meaning that you are not a criminal, right? You do not have a criminal history that would affect a unreasonable person seeing you as a person of good moral character. If you do have a criminal history, you want to make sure that you are including evidence that shows that you are a good person, right? To counteract that criminal history. Again, with these, you want to make sure that you are working with an immigration lawyer that understands T visas and that can craft your case in order to make it as approvable as possible, okay? The one thing that you should know about the T visa, in order to apply for a T visa, you do have to report the trafficking to a law enforcement agency, okay? There's no way to apply for a T visa without that reporting. And this is where people get hung up on T visas and choose not to apply. But there's so much benefits to applying for a T visa that honestly, you should consider it if you have been a victim of labor trafficking or sex trafficking, okay? It's really important that you don't let the fact that you have to report the trafficking, because sometimes the person gave you a job when no one else will, right? And you don't want to seem ungrateful. But if they have taken advantage of you, if they have not paid you what they were supposed to pay you, if they had you working 100 hours and only paying you like $100 for it, that is not right, okay? And the U.S. labor laws really want to make sure that everyone is on the same playing field so that U.S. citizens are not disadvantaged by the fact that people are being labor trafficked. Right now, it's taking about 1 year to 2 years for the T visa to be approved. And then you can apply for a green card within 3 years of that approval. However, if the law enforcement agency has closed the case, meaning they have investigated, they are done with the investigation, they have closed the trafficking case, you can then immediately apply for a green card and not have to wait the 3 years. Okay. So just keep that in mind with the T visa. The time frame between applying and being able to apply for a green card is really short versus asylum and U visa. So based on that, I'm sure you can see why the T visa is one of my favorite things, because it really can take someone from not having status to getting a green card within like 3 to 4 years, right? So it is one of those things that we encourage our clients to apply for if they qualify. So that's really the key here with all of these things. You want to check if you qualify. I did a video last week, talked about the 5 things you want to do before Trump 2.0 happened. And one of those is figure out what you qualify for. And this video should give you some ideas of what you could qualify for so that you can go and start talking to immigration lawyers and figuring out what your options are. The 5th and final thing is an employer-based application if you are 245I eligible. So this is very specific, okay? Most people are not going to qualify for this, but if you had a family-based petition, a very old family-based petition that you never followed through on, or it was approved, but it just never materialized, you want to look into that, okay? Let's say someone filed for your father and it was like, 30 years ago and nothing really happened with it and you're just not sure. You want to find out what happened with it, okay? Because if it was approved, you may be able to apply for an employment-based visa, an employment-based green card without having to leave the U.S., without needing to apply for a waiver, even though you're here undocumented. Because that 245I, if you're eligible, will waive the fact that you are undocumented in the U.S. and you'll still be able to adjust your status. This is important because if you have overstayed your visa, if you entered without inspection, if you are undocumented in general, you would not qualify for an employment-based adjustment of status because it requires you to have current status. So an employment-based adjustment of status requires you to have status in the U.S. before you can get a green card through that employer. Okay. So, but with a 245I, if you are eligible for it, it doesn't matter if you're out of status. It doesn't matter if you're undocumented. You would still be able to apply for adjustment of status in the U.S. if you are 245I eligible. So if you know in your family history that someone filed for you like 40 years ago, someone filed for your parents and you were already born and included in the application, you want to find out. Okay, if you're not sure, get a USCIS, a Freedom of Information Act request out there, get the information, see what happened with that application, because without knowing it, you may actually qualify to adjust your status and you just don't know it. So this is the 5th option, is to check if you're 245I eligible. And if you are, then you may want to start looking for employers that are willing to hire you and apply for a green card for you so that you can adjust your status to that of a green card holder. All right. So I hope that has given you ideas of what current immigration law is and what you can do now, right? So if you qualify for any of these, you may want to start working on them now and get your applications in there. We know that on January 20th, a lot of things will change. Like I said, asylum will be limited. U visas will be limited. And I'm sure T visas will also be limited as well, as far as how long ago did the trafficking happen. So we want to pay attention to those things. However, as of today, these are the laws that are still in place. And if you qualify for any of these, you want to get your application filed based on the current laws. When laws are changed in the future, you may be covered by the current laws today and not the changes in the future. So if something changes on January 20th, where they said that U visa is only for ongoing investigations and your crime happened 20 years ago and you didn't file for your U visa, now you're out of luck with the U visa. If they say that the T visa is only for trafficking that happened within within the last 5 years, and yours happened 20 years ago, you would be out of luck. So you want to get these applications, figure out what you qualify for, and get the process started now and not wait. Okay. So that is really what this video is about, is to give you ideas of what you may qualify for and encourage you to schedule a consultation with an immigration lawyer and actually find out what you specifically qualify for, because that's the only way that you can know if you qualify for these things, especially for the 245I. That's really legal specific. And you want to make that analysis on your own. So definitely get that consultation done. If you would like to schedule a strategy session with me, you can do that by going to my website, lilylegal.com, and clicking on Contact Us, where you can pick a date and time that works best for you for us to talk. Or you can call my office at 508-443-1788. As always, I will continue bringing you updates on any of these things. So if anything changes on January 20th and beyond, you'll be hearing it from me, especially with these visas and status changes that we are expecting. I will be updating you all on every single one of those changes. So stay tuned for that.